there a danger to adding your child to your bank account? My name is Bridget Finke, and I'm an attorney at Bakke Law Offices. I'll frequently have clients tell me that they don't need a financial power of attorney because I've added my son to my checking account, or I've added my daughter at the bank. I always request more information from the client because there are 3 different ways to add a child, and those 3 ways have very different results. Unfortunately, the most common answer is that the client has made his or her child a joint owner on the account. The reason I say unfortunately is because joint ownership of a bank account in Wisconsin often gives the child much more authority than the parent intended. The child has the complete authority to withdraw money from the account. That's a good thing if the child uses the money to pay the parent's bills. It is not a good thing if the child uses the money for him or herself. A parent may say, "My child would never do that." Even if the child may not, the child's creditor may indeed do so. If the child gets sued or is in financial trouble, a creditor could garnish or seize the parent's money to pay the child's debts. If the primary reason for adding the child is to give the child the ability to pay the parent's bills, then I suggest a second way of adding the child as a power of attorney, or POA, on the account. Some financial institutions may refer to this as signature authority. The POA designation gives the child the ability to write checks without giving the child any actual ownership of the money. It also imposes legal duties on the child to use the money for the parent. If the primary reason for adding the child is that the parent wants the funds to pass non-probate and be immediately available after the parent's death, for instance to pay for the funeral, then I suggest a third way of adding the child, adding a payable on death, or POD, designation to the account. Using this strategy, the child does not have any ownership interest during the parent's life and only receives the money after the parent's death. The POD designation offers the same advantages of non-probate transfer as joint ownership, but without the risks during the parent's lifetime. You can also have more than one child as a POD beneficiary. I also encourage clients to be cautious about joint ownership or POD designations because they can raise questions of whether the money was truly intended to be used for expenses like medical bills or the funeral, or whether the money was simply given to the designated child or children. Unless the bank documents clearly say something different, if a child is a joint owner or a POD beneficiary, they have no duty to utilize the funds for the parent's estate expenses or to contribute the funds to the estate. Consider whether the quick availability of funds is worth the potential confusion as to whom the funds actually belong. Confusion can escalate to family feuding if only one child is named on the account to the exclusion of other children. It's also important to note that the second and third strategies, POA and POD, can both be added to the same account, giving the benefits of the first strategy, joint ownership, without the risks. In other words, a parent can give the child power of attorney or signature authority during the parent's life and have the child as payable on death beneficiary to receive the funds after death.